It's just the fact that I am accused of escaping. But that accusation has been implemented already by correctional services. So the point is, why am I going to a criminal trial where I'm already guilty of a crime that I'm supposed to go and defend myself? Because even if I defend myself and I can showcase that, and I sigh to say this, that there is more than overwhelming evidence that I have and my legal defense has, that we are 100% sure I would never be in a position where I'm found guilty on escape, because the escape is not a typical escape where a person broke out of a wall and jumped, Your Honor. It's a situation where somebody has been out for a very long time, and then they decided that this person is escaped. And in that, there are factors where they are a party to the proceedings in Bloemfontein. I am a party. But it seems that they have more power and basically don't value the Constitution, because they are in a position to make a decision, open a case, and then enforce certain unconstitutional circumstances on me. Because currently I have been in CMAX only based on the fact that I am accused of escape. I am currently left with less than 5 years that I'm supposed to be on parole. And in that, if this is the parole that they are claiming I should be on, so meaning that if we proceed, I'm still going to have another situation, because they're not providing rehabilitation, they're enforcing solitary confinement indefinite. In my papers, I have quoted JIC's report that says that in issues dealing with solitary confinement of CMAX in Ebongweni, is that it's unconstitutional to keep someone in solitary confinement indefinite. Now, when we deal with the urgent part of my application, the application rises on urgency on two case laws only. And basically it says that if a person challenges his unlawfulness in incarceration or detention, the court ought to hear the matter urgent, purely based on the fact that it could constitute to a violation of human rights and dignity. And that's substantially what I raised this urgency on, because of the fact that currently, Your Honor, I am in a situation where I don't have any rights. I am being moved from left to right. I am not given any rehabilitation. The respondents behave as I am supposed to be punished instead of understanding the correctional service policy. And in that self, I now have to defend myself. I can't defend myself with a person who's made a decision that I have escaped. The papers before the court, the profile in prison says that I escaped. But they also opened a case and they're asking the Bloemfontein court to make a finding. Did I escape? But they already decided. In that, they also take away the presumption of innocence. Now, in the presumption of innocence, Your Honor, there's several factors that deal with urgency on the basis that one cannot keep someone in prison and title him as a person that does not have fair rights. In that, I don't have rights in the way that I've been treated, purely based on the fact that the people that released me are the executive of this country. And because they do not want me to have a fair trial, I am now put in a situation where if I speak, I'm transferred to Ebongweni. If I do this, I'm treated in this manner. But I'm supposed to have an opportunity to present my case. I cannot present my case if I'm kept in solitary confinement. They filed my medical file, I think they added 3 pages. Those 3 pages are just a portion of my medical file. I've been in CMAX for 3 years. In that 3 years, I've picked up 4 illnesses because of solitary confinement. JICs have confirmed that solitary confinement is evident to cause harm on a person. Now, if I've lost my humanity because of the fact that I'm convicted of rape and murder, and I'm no longer a human because of the fact that now we do not consider a person that is accused of escape and is charged for other charges, and because of that, we are not going to give him a fair trial. That is the issue that brings this application before this court, because I find it challenging that the respondents would not allow me to be enabled to a position where I can defend and be able to argue my papers fairly. Section 32 of Section 32, Section 33, and Section 34. I do not have access to the court as I wish. This application was filed last year, December. The respondents responded very late to the papers, and we had to come to this court. I was physically in this court, and it was struck off the roll because I had no answering papers. And then I was transferred to Ebongweni. I only came back on Sunday, and I asked my team to act as promptly as they can. But under the circumstances, they only allow people that are accused and remanded in trial to have opportunity to be able to have a legal defense, to prepare for defense. They do not allow people that are incarcerated, sentenced, to have opportunity to defense. That's Section 17(4) of the Correctional Service Act says that they will only be prepared to give remindees to prepare for defense. They don't give that to a person who's sentenced. Now, in this sentence, the challenge is that the sentence that I'm serving is a question of the court. Now, I'm serving a sentence, the court could say that from the 13th till today, I had unlawfully served it and I have proven beyond a reasonable doubt that I was lawfully released and that the executive decision that was taken was correctly taken. What happened with whatever they allege with bodies and whatever, that has nothing to do with me. I have documentation that I should be given an opportunity to present before a court. And if that executive power is challenged, that's not mine. I refer to the case of Jacob Zuma, where he was released on medical parole. The Constitutional Court found that the Respondent Correctional Services violated and released the person unlawfully, but there was executive power and authority used, meaning that the person who was serving was not at fault. Now, in this condition, I am serving a sentence that we do not know if I should be serving it or not. The respondents are not in a position to determine that. In their papers, they say that I should hold the burden of proof to prove that I am responsible, to showcase that I had not violated the warrants of sentence and I was lawfully released. But they opened the case. They took that burden of proof and gave it to the state. The state must prove that I am guilty, and I have to defend myself. I cannot furnish my papers and my defense to the respondents so that they treat me different. I need to furnish that in a trial court, and a trial court needs to then make a decision. But in their papers, they argue that I have the burden of proof. I cannot hold the burden of proof when the person opens a case of escape from lawful custody, because the reason why we are having a challenge of this matter is because the challenge is based on the warrant of sentence. That warrant of sentence, Your Honor, is purely stipulated clearly that a person that is sentenced in correctional services must have a warrant. And when the person escapes, he doesn't escape from a building. He escapes from the warrant. That warrant is the challenge. Now, we don't know. They say that the warrant is valid. But only a court can make that's determination. Now, they're making determinations and classifying me. And if they put me as an accused person in detention, they do not lose anything. There's no harm that will be caused to the respondents. I will still be in their custody. I'll still go to court. I'll still defend myself. But it will be in a fair manner that is within constitutional rights of everyone. And that is all I am asking of this court, to take consideration that the presumption of innocence is a fundamental right that all are bound to go unto. But the respondents argue wrongfully that the burden of proof and the presumption of innocence do not apply to me because of the fact that I'm convicted. So basically what they're arguing is that because I'm convicted of rape and murder, which is a challenge in a different court, they feel that I have no right, that I cannot defend myself in this manner, that the warrants are an absolute. There is no warrant in the world that is an absolute, Your Honor. A warrant may be amended through the Correctional Service Act, through the executive power, through an application through the court. So there are many ways that one can actually not serve a full life sentence or 10 years of a sentence. There are many executive decisions that could be made. And if those decisions are made, you cannot hold me to ransom on the basis that you accuse me of violating. You must give me an opportunity to ventilate my case. And in this application, the center and the core of my argument is that I'm not able to be treated as a normal inmate, being given normal treatment. I am treated highly. All these people that I come in here, in security, it's based on escape. I have no violence. In the 15 years they claim that I have been in prison, there's no case against me. There's nothing against me. In the time that I was outside, I violated no one. Your Honor, I will bring it to this court attention that escape, it is a charge under the Correctional Service Act. And the Correctional Service Act charges me with escape, then makes a decision, and after making a decision, take me to court for the same matter. Now, technically, that means that the legislation itself, when you're dealing with what correctional services conduct is, they have supreme power over the Constitution and over my rights because they can act and do as they please. Currently, I'm in solitary confinement. They refused to take me out because they say that I should finish my trial in Bloemfontein. But that trial can continue for 10 years. And at the time I reach the trial, I might not be fit to stand trial. I will also say that the respondents are a direct interest to the trial in Bloemfontein. They have to prove that I'm guilty. And I am in their custody. That is sort of like taking a person that has violated someone and say that stay with the person that you violated. They're not going to treat you fair. They're not going to treat you with dignity. I am treated for this. I am the longest serving person after Robert Sibukwe in solitary confinement. I live in CMAX, not for everyone. I live solitary by myself. I see no human being for the past 3 years. And that is purely based on an accusation. There's no facts. I have not defended myself. And the respondents stand on the ground that I was sentenced. I do not challenge that I was sentenced. But I challenge the validness of that warrant. And I challenge it in the Bloemfontein court, not in this court. This court is to challenge, do I not have presumption of innocence? And do I not qualify to be innocent until proven guilty? The responsibility to prove beyond reasonable doubt is with the respondent and the state that I am guilty. And that has not been proven, but I have been treated as such. There are even judges that have made accusations to say that I am guilty of escape in transfer applications. Now you question yourself that would there be a fair trial in the circumstances? And do we say that because I'm convicted of rape and murder, I don't deserve a fair trial? I don't deserve a fair proceeding as required and guaranteed by the Constitution? Because that is the actual challenge here. The challenge is not that the respondents can put me in prison. I have no challenge in being in prison. But the challenge I just want an opportunity to state my facts. And in that process, be able to argue. Because my medical file has been attached here in this court by the state. But they only chose, and I don't have access. They do not want to give me an opportunity to make copies of that medical file and be able to give it to this court. But the court would see that since I have arrived from the 13th till today, I've lost 36 Ks in solitary confinement. I speak to no one. I only see people when I'm here. And it's overwhelming. But you have to chin up. Because at the end of the day, if you don't stand up for yourself in this country, politicians are going to run over you. And that's what I need to do. And I do this with humble respect to this court. Asking the court to look at the center of my urgency based on humanity. Based on the fact that I've been in solitary confinement and the correctional services have a responsibility in Section 2 to enforce programs of development and rehabilitation. Seems like I don't qualify for rehabilitation. Based on what? An allegation again. Because there's nothing else they can argue that I have done. Based purely that Thabo Bester has escaped. And that is the center of my argument, Your Honor, that I would like the court to look at. And also, in the proceedings and the process that was followed, to take a person from an airport and put them in prison as an administrator without any findings, without any ruling by any court, by taking any tribunal action, it cannot be correct. Because then it means our Constitution is giving correctional service absolute power above all rights. There's a document attached here that says that I was detained at 4 o'clock in the morning at Lanseria Airport by South African police, and they read me my rights, which was never done. The signature has nothing to do with me. And the challenge there is that the police say that they detained me, but I was taken to CMAX. So SABC is claiming that they took me in custody, and then you have correctional service who took me to jail. And then on my first appearance, the state prosecutor said that Mr. Bester is sentenced. There's no bail that needs to be filed for or argued. Now, automatically, meaning that my rights to presumption of innocence is taken away from me, purely on the basis of a decision made administrationally. Now, the challenge is that decision correct? Does it comply with the Constitution? Is it consistent with the law? And does it actually provide me with a fair opportunity before the court? Does it provide me with an opportunity to bring a defense? Because if you make a decision, Your Honor, the administration of correctional services, the separation of power, has been overlapped by the correctional services. They made a decision that has to be in a criminal court.
Mr. Bester, I think you've made that point. Okay. I don't know if you've got any other points to make.
No, I'll give them a chance.
Because I understood that to be the crux of your argument.
Yeah, no, we can give them a chance.
Because you were no longer in prison, and you are now in prison again. Your argument is the court cannot be sure what happened in that meantime.
Yes.
That you indeed escaped because it's a presumption of innocence. That's the crux of your argument.
Yes. And just dealing with the reason why I'm in prison now and why I am serving is based on a warrant.
Yes.
And that warrant is the reason why they opened the case. And that case is not fully ventilated. Yes.
So I'm just going for clarity through your notice of motion.
Yes, ma'am.
The first one is the urgency.
Okay.
Then you asked to be declared that you're serving a prison sentence unconstitutionally. So that's the nub of, I think, 2, 3, and 3, and then you want to be reclassified as a remand detainee.
Yes.
Just want to make sure. Then you've got the costs. Yes, so that's the crux of your argument.
Yes. And I think if we look at the issue of urgency, which is probably where the court would have to make a decision, is the challenge is that, Your Honor, in the papers filed as my reply, I did state that it's very challenging to file papers in court for me as the person in CMAX. And why I'm stating that is that the respondents say that it took me 3 years to file this, but if we look at the challenge itself and the constitutional standing of the application, is that it's never been challenged. So meaning that as a lay person myself, I had to do research and find that if it has a legal standing or not. So why I'm saying that is that it's very important for the court to take note that this application is brought in person. Second to that is that the circumstances of the application itself, there's no precedent application or a precedent case for me to have referred to, so where I could have acted promptly within the first 14 days of my arrival back. So that would be centered to my urgency, because currently I am in circumstances where the court, where the respondents believe that I should be kept in solitary confinement because I pose a risk or I had escaped, or however they may classify me. But in that, they put measures to limit me to be able to access the court. You understand? So
I think the issue with urgency, and perhaps I'm also speaking to the state advocate now, the problem with the urgency is if I'm with him, then the matter is urgent, because no person must be incarcerated unlawfully by the state. If I'm not with him, the matter might not be urgent, but for me to be able to determine the matter, it must be enrolled on the urgent roll. So that's the only problem that I think you can address me on with as far as urgency is concerned. Mr. Bester is finished.
yeah, you can proceed.
As the court pleases, Madam.
You understand my predicament?
I understand the predicament very well, Madam. In fact, Mr. Bester just went on to deal with merits and then later on deal with urgency. But the first issue is the issue of urgency. And my lady put it correctly. Has Mr. Bester been lawfully incarcerated? My lady, you will see that there is a warrant of committal.
Yes, but just I'm going to interrupt you. You understand, I only get to that question once I deem the matter urgent and hear it.
Yes.
Yes.
Yes. So I'm saying, in as far as that question is concerned,
Yes.
there can't be a question around the lawfulness of his incarceration, because there's a warrant of committal that commits him to detention. So his incarceration at CMAX then and now at the Bongweli is lawful. It's lawful because there's a warrant that exists. There's a warrant that has not been set aside. And it's not a warrant that can be ignored. In fact, that's the reason why when he was captured in Tanzania, that's the reason why he was taken to CMAX. It's not because of a classification or a description that he's a sentenced prisoner or a person serving a sentence. It is not that. It is because there's an extant warrant of committal that had to be complied with, that requires him to be incarcerated at CMAX. So agency cannot be founded on a supposition that his incarceration was lawful. It's lawful. It remains lawful. It was lawful then. It's lawful now. It continued to be lawful. But there's an important reason why this matter should not be had urgently. The important reason, really, my lord, my lady, is that Mr. Bester, from onset, when he was taken to CMAX in 2023, in April 2023, he was aware of his rights. He, in fact, even complained about his constitutional rights. He even launched a number of applications. There was an application that he launched in 2024 where he sought access to modem and a laptop. So he's a man that has always been aware of his constitutional rights, but decided not to approach court in that 3-year period. He only decided to do that when it suits him now, when there's a looming trial in November or December of last year. Now, that approach is impermissible. It means that he's a man who's been sitting on his laurels for 3 years. He's a man who creates his own agent. So he decides, no, this one, I will launch this application in November, December. My lord, my lady, that is impermissible. That is a clear example of self-created agency. There's another reason why this matter should not be had on an urgent basis. There is no ongoing harm. In fact, there's no harm that he's suffering at all. My lady, he concedes in his papers, in his replying affidavit, that he does not set out the psychological and physical injuries. He does not set out the sequelae of those physical and psychological injuries in his founding papers. He accepts that. Today he says, well, I was ill, and so illnesses are dealt with in the prison facilities. There are psychologists, and you would have seen from the papers, he has been consulting with psychologists in the facilities, in the prison facilities. An applicant in an urgent application has the responsibility, whether he's a convicted prisoner or a sentenced prisoner, has a responsibility in terms of rules, Rule 612B of this court, of the uniform rules, has got the responsibility to demonstrate that the matter is urgent. Now, when an applicant himself concedes that he has not demonstrated the necessary harm, what then should the court, why should then the court urgently intervene? To stop what? There is no ongoing harm. Why shouldn't the court listen to other matters? This is an urgent court. And then he says, well, look, I've considered that, but my point remains. There's been a violation of Section 35(3)H, the presumption of innocence. My lady, that argument is flawed. It's wrong. There is no violation of Mr. Bester's right to be presumed to be innocent. He's an innocent man as far as the new charges are concerned. He remains innocent. It is the responsibility of the prosecutors or prosecution in that criminal trial to prove that he is guilty of the new charges that he is facing. He has got no response. The classification, or it's in fact the description, it's a classification, but it's not really a decision that has been made by correctional services. It flows from the Act itself. The Act defines him as a sentenced prisoner. Why? Because in 2012, the Western Cape High Court found him guilty of rape and robbery with aggravating circumstances. It made that finding. It made that finding and even issued a warrant of his committal. It is not correctional services. So he is a sentenced prisoner, and he is not a remand detainee. Now, the law is very clear. If you're a sentenced prisoner, your right to be presumed to be innocent, and as far as the crimes that you've been found guilty of, it ends when you are sentenced. And my lady, we've referred in our heads to authority in that respect, and literature in that respect. So when he was convicted by the Western Cape High Court and sentenced to 25 years and life imprisonment, his right to be presumed innocent in relation to those crimes ceased. And the classification or the description that currently applies relates only to that. It doesn't relate to the new charges. It must be clear, it does not relate to the new charges, and it doesn't even say it relates to the new charges. In fact, Mr. Bester himself, in his founding papers, he says, I'm being classified or described as a person who is serving a sentence or a sentenced prisoner. But no, that is correct. It's consistent with what the Act says. It defines a sentenced prisoner in Section 1 of the Act. And I'll read it just for the record. This is in Section 1 of the Correctional Services Act. And I quote, sentenced offender means a convicted person sentenced to incarceration or correctional supervision. That warrant of committal, my lady, which you would find on case lines 005-23, is clear that the man was convicted, given 25 years, and also sentenced to life imprisonment. He fits correctly. He fits squarely within this definition. Now, the law is clear. If you are sentenced, you cannot be presumed to be innocent in relation to those crimes for which you are found, you're convicted of. But Malik, let me just one point, Malik. A remand detainee, because that is what he seeks to portray himself as. That I don't know, I'm a remand detainee because I'm facing escape and other charges, arson, corruption, very serious charges that he's facing. But that is not correct. Let's look at the definition of what a remand detainee is in terms of the Act. And I'll read it out. This is also in Section 1 of the Correctional Services Act. It says a remand detainee means a person detained in remand detention awaiting the finalization of his or her trial, whether by acquittal or sentence, if such person has not commenced serving a sentence or is not already serving a prior sentence. Now, on common course facts, Mr. Bester does not meet that definition. He's a person who is already serving a sentence for rape and murder with aggravating circumstances, my lady. So he's not a remand detainee. He's entitled to be treated as a sentenced prisoner because he's a sentenced prisoner. My lady, I interrupted you. You wanted to ask a question before I can proceed.
You directed me to 005-23.
Yes, my lady.
Which is the warrant
of committal.
And it is your case that he is currently incarcerated in CMAX on this warrant.
Yes, he's now at Ebongweni.
Yes.
Yeah, last week we were in court where he was trying to get himself back to CMAX. But CMAX is his center of origin. That's where, when he was captured in Tanzania, that's where he was taken.
And just because I understand his argument to be that it might be that was the warrant that committed him, but we don't know presumably because of the presumption of innocence, how he was no longer in prison before he was incarcerated again.
Yeah.
Yes, so that's how I understand that argument to be.
Yeah.
So my question then is,
Yeah.
even if he was released on parole, for instance,
Yeah.
he would still be a sentenced offender, right?
That's correct.
Until the 25 years.
Yes.
It was 25 years. Well, it's life, but
Yeah, until the expiry
of that.
of his sentence, or if he's paroled, or he's
But if you get
But-
life sentence, that is for life. You are sentenced
that's for life.
offender. You can just get parole after 25 years.
Yes,
So it doesn't change your classification as a sentenced offender
it does.
in terms of the act.
Yes,
My lady?
You will get an opportunity to
you get an opportunity. Yes, my lady. So, my lady, Mr. Bester alleged that, and that I should address squarely because ladyship also mentions it. He says that he was a free man in that period, that is between April 2023 and when he was captured. Sort of May 2022 and April 2023, that he was a free man. He makes that allegation in his papers, but he does not support that allegation with any evidence that he was a free man. And we say he was not a free man because he was not on leave. He had not been granted any leave. He was not on parole. He had not been pardoned. He was not legally out of the GS4 security facility. He had escaped. And the warrant still remained. The warrant still required him to be where? To be in the correctional services facilities. So that argument is completely flawed. It cannot be, my lady, because it would mean, in fact, I was reading in the papers some few weeks back that there's a prisoner who escaped and was captured here in Gauteng. It would mean each and every prisoner in this country who is currently incarcerated may just have to escape to attain freedom. My lady, that would be absurd. Because a court sent this man to prison, to incarceration. The warrant remains. It says he must be there. Now, for you to be out of incarceration lawfully, you must either be paroled, you must be given leave, or you must be pardoned. So that did not occur in respect of Mr. Bester. So he has not discharged on balance of probabilities this allegation that he makes that he was a free man. He is not a free man. The warrant required him to be in the prison facilities, and there's absolutely no violation of his right to be presumed to be innocent when he's returned to the facilities, because the warrant requires him to be there, and he is guilty of the offenses in relation or mentioned in that warrant. The classification is based on that, my lady. The classification is simply based on that, and is not a decision that is. It's a decision that flows from the act itself. That, as I have read, that the man has been convicted. He does not complain about the security classification as he wishes to now suggest, that he's a maximum, he holds that maximum status, legal status. That he holds, and that is not a question in this proceedings. So the matter cannot be urgent. Also on the basis that there's no violation of Section 35(3)(h) or presumption of innocence. The matter is also not urgent, my lady, because the applicant has a responsibility himself to demonstrate to this court as to why the matter is urgent. And he says in his founding papers, hey, I don't know the date on which I became aware that of my rights, my constitutional rights and so on, my lady. And I've addressed that in my head and say, but he has a responsibility so that ladyship and the respondents must be able to know as to what is the circumstance that give rise to, when did the circumstance that give rise to agency come about? And he doesn't do that. He doesn't say when he became aware. So he leaves this court and the respondents together as to when he became aware. But we know, and I've addressed it, we know that he has always been aware of his constitutional rights, and he has actually launched several applications, and he has lodged a number of complaints with Mr. Kabengu at Khosi Mampuru. So it's a case that really is hopeless as far as agency is concerned. And the issues that he's raising, these are issues, my lady, you'd forgive me, my lady, my heads are about 75 pages because they are constitutional issues of importance. Somebody might mistaken what Mr. Bester is saying to be the law. There's no law, my lady, that says that a person who has been found guilty must be presumed to be innocent. The position is very clear. If you are found guilty and sentenced, you're guilty. The presumption doesn't apply there. It only applies as far as the new charges are concerned, and for the new charges, this has got nothing to do with the classification or the description that he has brought to this. That is the issue before this court, that there is a classification. But what is the link between the classification and the new charges? Nothing. Nothing. Zero. He says the classification says, I'm a person serving a sentence. Is that not the truth? Is he not a person serving a life sentence? He is, my lady. He has been sentenced by the Western Cape High Court. Mr. Bester must not waste this court's time. So the point we're making, my lady, and I've referred to a number of case law, if there are issues that are complex, those are issues that should not detain an urgent court. They must go to an ordinary opposed motion court where the issues would be properly ventilated. He has not, in fact, addressed why he can't obtain substantial redress in a hearing in due course. That's another requirement for agents. That has not been addressed. And we know, we're with his legal representatives 2 weeks back on 3 March when he was trying to get back to CMEX. We know that the trial is only beginning in the 3rd term. That is around 26th of August. So if this matter as it should be struck, if it is struck, he would still have an opportunity to place it on a normal opposed motion roll. He has not advanced any reasons. He is a man who can wait 3 years to approach court. Why can't he wait a few more months to enroll it on a opposed motion court? So, my lady, squarely, the matter is not urgent, and my lady, I don't want to detain the court further and take you through all what I've said about agency in my hairs of argument. But ladyship has my hairs of argument. My lady, I'm not sure if I should stop at this stage so that my lady can make a ruling on agency, and then we'll get to the merits, or whether I should just.
I am going to reserve both the urgency and the merits, so I'm not going to make any ruling
Yeah.
today, because I think the merits and the urgency can be interlinked.
I have been intertwined. I agree.
Depending on who's
Yes.
finding, yes.
Yes,
That's why I put it to you in the beginning.
Yes.
That if I am with Mr. Bester,
Yeah.
then the matter might well be urgent.
Yeah.
Or if I'm not with him,
Yeah.
it might not be urgent, but for me to determine
Yes. You have
that
to,
I need the merits.
yes, you need to think about the
Yes.
lawfulness and so on.
It's one of those cases.
Yeah, yeah. No, I appreciate what that. My lady, I've addressed the issue of lawfulness and all that. I just want to address the the relief itself, my lady. The relief is incompetent. The relief is incompetent, is not one that ladyship can make. Why? Why we say that? Well, he says my incarceration must be declared unconstitutional, but there's an extant warrant of committal. So my lady, you can imagine there'll be prisoners coming here and saying, hey, I've been sentenced, then it's unconstitutional, even when he had all the opportunity to deal with that for which he has been sentenced for in that criminal trial. So my lady, we say that it is incompetent for that kind of relief to be granted, because it can't be granted on the basis that he seeks, that his presumption of innocence has been violated, because the presumption would not apply as far as that incarceration is concerned. As far as that incarceration is concerned, it's related to the fact that he has been found guilty and sentenced. So the presumption of innocence does not help him there. It doesn't. He has been found guilty. He must stay in the prison facilities. Then, the relief requiring his status and classification as a sentenced prisoner to be declared unconstitutional is also incompetent. It's incompetent. Because his legal status is not something that is determined by correctional services or the respondents. No, it is not. It's something that is determined by the law. The law says, and I've quoted the provisions of Section 1. If you commit a crime, you're sentenced, you run a trial, you're sentenced, then your legal status is that of a sentenced prisoner. And he has considered that. Importantly, you can't grant such relief because by law, Section 2A of the Correctional Services Act requires correctional services to enforce the sentence. It can't turn a blind eye. It can't ignore that sentence. That the sentence is there. It exists in law. It also exists in fact. It can't turn a blind eye on that and not enforce it. So it would really be incompetent for a court to grant such kind of a relief. Because you would imagine then everybody will come here and say, well, look, I've been sentenced, but my right to be presumed to be innocent is violated. Please release me. So we say that if he wants to do that, he must challenge the law itself. If the law says Mr. Bester is a sentenced prisoner because he has been sentenced by the Western Cape High Court or whatever court, that is what the law says. And that is what the Act says. Then he must bring an application and challenge Section 1 of the Correctional Services Act. He has not done so. So my lady, the law, which is Section 1 of the Act, remains valid. It remains of legal force. Now, until that is challenged and declared unconstitutional or whatever the case is, DCS is entitled to enforce it, to enforce the sentence. So you don't want to find yourself, ladyship, having made a declaration that is inconsistent with the law as it exists. So you must challenge that law first. And the relief requiring his reclassification as a remand or awaiting trial prisoner is also not competent. And I've addressed that, my lady. But just to emphasize, the man, Mr. Bester, is not defined as a remand detainee. He's not an awaiting trial detainee. He is like many other offenders in the facilities. he has been sentenced, and then he has got further charges. It's a man that must be treated like that. The court cannot craft out a new definition of a remand detainee. In fact, the word awaiting trial prisoner, which he prefers, it's a term that has been dropped in the new act. There's no such thing as awaiting trial prisoner. It's a remand detainee. Mr. Bester is not a remand detainee. He's a sentenced offender. There's no way that the court would have to craft a new definition to suit him. There's nothing special about Mr. Bester. He's a convicted murderer. He's a rapist, and he has been found as such by a court of law. Those sentences must be enforced, and he must serve those sentences until the expiry of that sentence, or until he's granted parole. He can be paroled, and that's the law again. He can be paroled, he can be pardoned, he can be given leave if he wants, if he applies for it. The relief requiring the solitary confinement to cease and so on. My lady, Mr. Bester is not in solitary confinement. He says himself that he has been moved to Kokstad. And CMAX, so this application is also overtaken by events. CMAX is not solitary confinement. I've been to CMAX. It's got multiple cells. And we have addressed this in our answering papers. There are multiple cells there. There's interaction with the people who are in there are able to interact, walk in the corridors, exercise. When they exercise, they interact. They may interact with the officials or even other prisoners. But he has not pleaded any facts. And remember, he's the applicant in these proceedings. And he says, well, I don't have to prove anything. But he's the applicant in these proceedings. If you bring an application in civil proceedings, you shoulder that burden. And he must not confuse us to be saying that he shoulders the burden in the criminal proceeding. He doesn't in the criminal proceedings as far as the new charges are concerned. But in these proceedings, where he says that he is in solitary confinement, he must adduce those facts and evidence. You can't just make a bold statement and say, I'm in solitary confinement. Must adduce evidence to that effect, so that the respondents can deal with that evidence. He has not done so, and he has conceded to that in his replying affidavit. So it's not something that should bother this court. In any event, Mr. Bester is no longer at CMAX. I understood this morning that he has been moved temporarily just for him to be able to attend court. I think he was in court on the 19th in relation to a pre-trial, and then he's here today. But he's a man who is temporarily at CMAX. He's a man who the court in Pretoria on the 3rd said that he's a man that must be in Kokstad, in Ebongweni, for security reasons. He tried to get himself out of Kokstad, but he is there in Kokstad. So the conditions now that applies at CMAX are now irrelevant, because the man is no longer at CMAX. He's a man who's at Kokstad. So the conditions should also, on that basis, not detain this court. To wrap up, my lady. My lady, yeah, let me wrap up on this, my lady. My lady, what is happening to Mr. Bester is consistent with even international human rights instruments, and I deal with that in my head. Sentenced prisoners should be kept separately. You'd see that in our heads. And it's not practical to ignore his sentence. He's basically saying, ignore my sentence, apply the presumption of innocence, get me free, he wants to walk. That cannot happen. That sentence must be completed. And he has suggested that he's been discriminated and that there's a violation of Section 9, the Equality Clause. But my Lord, I mean, that has no substance. We have demonstrated that he's a sentenced prisoner. He's not similarly situated to unsentenced prisoners or remand detainees. So the differentiation that would be there would be justified because he is not similarly situated to remand detainees. He is afforded the treatment that sentenced prisoners are accorded to. And the Act, in terms of that, the Act does mention how he must be treated as a sentenced prisoner and how remand detainees must be sentenced. And there are legitimate reasons why that should be the case. International human rights instruments do also bear us out, and we refer to them. For example, my lady, he's a sentenced man. He can't be mixed with unsentenced prisoners. Human rights instruments and literature on this do say that sentenced prisoners may exert influence on unsentenced prisoners. For those reasons, it does not make sense to mix them. In fact, even our own very Act does say that they should not be mixed. So there are important, good, legitimate reasons that exist for him to be sentenced, to be kept separately, because he's a sentenced prisoner. My lady, I've quoted the Act. You'd see it from my heads. He has alluded to the issue of unfair administrative justice, and I say, my lady, he has not pleaded the facts to support that. But the important thing is, there is no the description or the classification. This is not a security classification which happens in terms of Section 29. This is a description of how he's described based on the warrant, because the warrant says he has been sentenced. How else do you describe him? I'm an advocate because I've been admitted by the court. Somebody can say, Mr. Madiba is an advocate. Somebody can say Ladyship is a judge because Ladyship has been appointed as a judge. He has been sentenced. He's a sentenced man. He's described as such. It is not a decision that I think he can set aside on the basis that he suggests. He must challenge the law. So, my lady, we deal with that, and well, we've said that he had not pleaded the facts. There are no facts in any event that deals with that. But if he thinks that should be set aside, I mean, he should bring a review application or a competent application. Then I dealt with the issue of equality and referred to a number of cases. And then lastly, my lady, he says there's been encroachment of judicial functions or separation of power. He says the conduct of the respondents constitutes a dangerous encroachment on judicial functions. My lady, I mean, that is far-fetched, has got no merit at all. The Act Section 2A requires the department, the DCS, to enforce the sentences. No, that does not encroach. I mean, it doesn't make sense at all. It's not an encroachment. It's the power. It's the function that has been vested with them to enforce the sentences which are issued by the courts. So that does not encroach on your powers. And I quote relevant sections. He's been kept there because there's a valid warrant, and Section 6 does enjoin the department to keep him in detention. My lady, just to conclude, then, I mean, we conclude. I mean, the courts do recognize this distinction between sentenced and unsentenced prisoners. And we refer to Zealand and many other decisions there. So the man is a sentenced prisoner. The right or presumption of innocence does not apply as far as that is concerned. It only applies in relation to the new charges that he's facing. And in relation to those new charges, the state, the prosecution, still has the burden to prove that he has escaped. We're not keeping him because of the escape. We're keeping him because of the warrant that is extended. He has ample opportunity to deal if he so decides. He's not been compelled to testify in that criminal trial. The classification doesn't say that, or the description doesn't say that. I mean, on this cluster of rights associated with the presumption of innocence, it does not say that he's not required to remain silent in the criminal trial. It doesn't say that. So, my lady, the story about the violation of the right to be presumed to innocence is a far-fetched story. It's a story for another day. It's not a story for this court. My lady, I would leave it there, unless if there are questions.
No, just for clarity, firstly, I would ask for the matter to be struck
Yes.
for lack of urgency.
Yes.
Alternatively, if it is enrolled with an urgent matter,
Sure.
then your heads of argument said dismissed
Dismissed.
with costs.
It must be dismissed with cost. And the reason why it must be dismissed with cost, my lady, I mean, the department really, this frivolous applications cop, he's bringing these applications all the time. We were in court on the 3rd of March. I think he was in court previously. He still has other applications and so on. And this one is an abuse of process. He brings an application 3 years. 3 years when he knew that there would be a trial that would happen in relation to the escape. So he only come 3 years in December. It's an abuse of court process. He should have come to court earlier. This, yes, my lady. So, my lady, yeah. So, my lady, I mean, this is a matter that should be struck off for lack of agency. If the receipt is not with us there, I mean, the matter should be struck on the merits, really. And we've set out the basis for doing so, my lady. As the court pleases, my lady. And thanks for the time.
Mr. Bester, you have the right to reply. I'm going to remind you that your reply must be restricted to issues that
Perfect.
he raised that you did not raise in your case.
Okay, thank you so much. Your Honor, I do believe that the respondents do not understand the application. From the answering affidavit to their heads and to the current papers, the argument is not my conviction of rape, murder, and etc. The challenge is, if the respondents accept it or not, I was a free man at some point. Now, Section 12 of the Constitution, Section 35, has procedures and clearly stipulates constitutional ways that they need to conduct themselves after they have enforced or opened charges. Now, if we look at Section 12, it deals with the security and freedom and liberty of a person. A person is free and is outside, and the correctional services decides that this person has escaped after a certain period of time. Whatever the merits are in the criminal court, the basis of that escape is based on the warrant that the respondents are basing it on, which is the conviction, which they are correct. But the conviction is not an absolute. A person sentenced to life, Your Honor, has 4 measures where they can be released prior to the life sentence. There can be an executive power from the president to pardon that life, and he can be immediately released, and he's no longer on parole. I was not on parole. I never signed any documents. But the respondents miscue and misdirect the application. The application is not for my classification. The question at the heart of this application is it correct to accuse someone of a crime, and the crime that you're accusing use the same measure to enforce. The respondents basically say that I escaped from a warrant of sentence. They enforce the warrant of sentence. But they do not finish this court to say that this warrant that they're enforcing, how was it set aside? How did I go out? That answer is in the criminal court. The question that has been asked, is it correct? Does it infringe my presumption of innocence? If you say a person has stolen money from a bank, and the bank goes and takes the property of the person before the court makes a decision, that is a violation of the person's rights. Now, that's exactly what they have done. They accuse me of escape, which they have the right to do so. Now, when they accuse me, I have to come to court and represent myself. They enforce the sentence. Now, meaning that the question before the court, the criminal court, is no longer valid. It's moot, because the fact is that if I win the case of escape, I still serve the sentence, Your Honor. If I don't win the case of escape, I still serve the sentence. Now, what determines the sentence to be valid or not? It is not their view. It is not. It is not their reply in these papers. It is the criminal court, because the criminal court is going to look at how long was I in prison, what authority was used to set aside or to release me, or if I did escape, and why did I escape, and all those measures. But the challenge here is not the escape. The challenge is, do they have the authority, the authorization, through the jurisdiction of power? Can they make a decision to open a charge, then implement a sentence? That is at the heart of this application. Other issues are irrelevant. The respondents misdirect the application completely, Your Honor, because they do not understand that I don't challenge my conviction. That is a challenge on appeal in a different court. I don't challenge my classification on my sentence. I challenge it based on an escape. They say I escaped on the 3rd, took me, put me in a jail, and said, you are serving a sentence. Now the court can decide that this warrant was actually invalid. The president had given me presidential pardon, or whoever, depending on how it's argued. But that answer does not lie with the respondents. The respondents opened a case, and justice says that I have the presumption of innocence. So if I'm presumed innocent of escape, it means I'm presumed innocent of not violating my sentence. You cannot separate the sentence and escape, because the escape arises from the warrant. There wouldn't be escape if there wasn't a sentence. And you wouldn't say a person escaped if you don't feel that this warrant is still valid. But the question is before the criminal court. Now, the presumption of innocence play part when you enforce the sentence that you are questioning, was it violated or not? That is the technicality that the respondents still at this point in their arguments still don't address. They address issues of my sentence. I don't challenge my sentence. I challenge that a person can be free and correctional service can decide that this person escaped and enforce the warrant. And there's no one to do checks and balances if it's correct or not. That is at the heart of this application, nothing else. That is what I am asking. The classification of being a sentenced person, being a remand person, that is terms used by correctional services. To me, the question is, do I have the presumption of innocence? If you look at Q8 of the attachment, annexure of the respondents, they put my profile here, and Your Honor, under category, they write here, escapee. They wrote escapee, but they accused me of escape. And they want me to prove, and they want to prove a case, but they already made a decision. In the court, the counsel is referring to in Pretoria, it was never said I must be in Bongweni. It said I must take the matter on review, not an urgent court. It was never argued. It was never said it was valid and it was lawful. The other fact that counsel deals with incorrectly on is that my sentence is not an absolute. That's the challenge here. And that is why there's a court and there's a criminal justice that says everyone accused has the presumption of innocence. It's to balance that a human being should be able to have the security of their liberty intact until there's a profound decision made by an honorable court to say that there's overwhelming evidence proven by the prosecutor that they have shown the burden of proof and beyond reasonable doubt, I'm guilty of escape. That escape is a word. The basis of that is that you violated a warrant of sentence. Escape is a terminology that is used by Correctional Services Act It is not a terminology of law. The law interpretation of warrant violation is then understood by correctional services as escape. And the challenge here is, Your Honor, the challenge is the warrant that sits before this court. That sits before the respondents. Could it be violated, or could it be still valid? Now, this court is not supposed to answer that question. But the question the court's supposed to answer is, do they not infringe my right by titling me and treating me as an escapee prior to findings in the criminal court? That is all we are asking. We are not asking the court to set aside that warrant. If right now I was declared as an accused person, which they have went and accused me of a crime, which I am entitled to my rights, if you accuse a person, he can be kept in prison. What correctional services choose to title that person is not really a legal point. It can change as it goes according to administration of justice. But the challenge here is, would the respondents be in harm or infringed if the court had to find that the presumption of innocence is breached by the conduct of the respondents? Because, Your Honor, with all respect, they say there's a warrant and they refer to the annexure of the warrant. But how does this court know that that warrant is valid? And what makes a warrant valid and not valid? It is a criminal court to determine, because you would have to bring documentation, or they would have to bring evidence to say there's nothing as parole, there's nothing as presidential pardon, there's nothing of executive power that excluded, that said that this sentence is ended and Mr. Bester should be released. Now, I say that it is my presumption of silence in the proceedings of criminal court under fair trial rights that I should not answer that. Your Honor, the counsel also misleads the court by saying that they do not ask me to furnish the court and demonstrate if I was released by pardon or other means. They clearly state that if I have any form of release officially, I should bring it forth. Now, the prison in question is a private prison. And in that private prison, I can tell you by the Correctional Service Act 116 states that National Commissioner, the Minister, and the President, these three people are the ones that could have made a decision. And that decision I can only disclose in a criminal court because I am not challenging it. In this court, I am asking the court to ask and to check, did correctional services conduct themselves within the rights of a person accused? And is my rights not infringed? Because the counsel argue urgency and says that the trial is going to be whenever. Your Honor, the trial is not going to be at whatever stage. The trial is overstanding for 3 years. And it had to be started a long time ago. But because of technicalities and because of the fact that the respondents themselves, who are a party to the proceedings, because they are the complainant, they are the ones who opened the charge against me, because I'm charged under Correctional Service Act 171 of offend of escape. They basically opened the charge. And in that, Your Honor, the court that I'm standing before, if my standing before that court is not correct, it infringes my preparedness to stand trial and to prepare for a fair trial. My fair trial stands at question where it is violated, because the respondent clearly stated that the accused or remand person has the right to defend himself. A person's sentence does not, right? Now, he argues that I am a sentenced person because of rape, and he keeps agitating the fact that sentenced. But the question is that they have not demonstrated, beyond reasonable doubt, that their decision was taken administration of justice, that I was able to defend myself when they said, okay, you are going to serve a sentence, that I could have furnished them with documentation that says I got a presidential pardon or whatever terms I was released on. They never gave me that opportunity. Now, that is the challenge of presumption of innocence, because once you make...
Mr. Bester, I'm going to remind you that you have made your case.
Okay, I just want to deal with urgency then. Your Honor, when it comes to urgency, the respondent keeps saying that I consented to not furnishing this court with papers that demonstrate beyond reasonable doubt why this matter is urgent. Your Honor, when there's a violation of human rights, which is at hand right now, because the respondent keeps saying that I am not in CMAX, I am at Ebongweni. They basically try to show that I am so oppressed because of escape. There's no other reason that they bring before this court. And that reason is on the basis of they made a self-judgment. Because of a warrant they believe was not violated. But it's a belief, it's not a fact. It's not an absolute point that they can bring. That's why there's a case. If there was no case, we wouldn't have that. The urgency rises also on the fact that he says that there were illnesses. Your Honor, take note, we put this in my replying papers, that all documentations that are held in correctional services, be my medical file, be it any document that I could demonstrate to this court, that solitary confinement is living and is visible in CMAX. I cannot do that because it's in their possession. They took certain pages and made it annexures to this application. Those annexures do not demonstrate. And I asked this court if the court has to look at the fact that how solitary confinement impacts me. JIC's report has been added as my answer. JIC's has made a finding through the inspectorate judge that CMAX and Obongweni is 100% solitary confinement unconstitutional. This is before me. This was a finding without me. And now I'm not even in that CMAX that JIC's makes it and makes that determination. I am kept completely alone by myself for 3 years with no contact except legal visit and family visits that last for 1 hour and 30 minutes. Now, if you say that that conduct is correct and it does not trigger urgency, what about the time I have to go to trial and I'm not fit, which I believe is the respondent's strategy? If you look at the current file, I was transferred on the 26th. At this current moment, when I was transferred to Ebongweni until now, I have now an illness because of the transfer. And that's why they brought me back. The current situation is that my incarceration has more impact on my trial and my physical being. And if this court understands that the warrant of sentence is the foundation where they base every argument on, which is I escaped. There's nothing else that they argue. I'm not a violent person. I've hurt no one since I've been in prison, even when I was outside. The murder and rape are a different application in a different court. I don't want to deal with it now. But what I want this court to take note is that every single element that I've raised, why this application triggers urgency, is because of the conditions. And those conditions directly affects me. The point of 3 years of this application, Your Honor, a person cannot be kept in a place where you cannot access a court and you cannot access documentation. They've added complainant request in this application. The complainant request clearly states, there was a time I was requesting books. For 2.5 years, they never gave me books. So how could I have known that there was a violation on the conduct? And the counsel argued correct. This is an interpretation of the Correctional Service Act, but it's sitting at the fundamental point. The presumption of innocence is violated through a conduct, not through the warrants. The warrants are a question in a court, but they enforce it, meaning that I am guilty to presume innocent, not that I'm innocent to be presumed guilty. And the urgency sits at the heart and at the foot of the basic treatment. I am at hand. You understand, Your Honor? And I would leave it there to make it short, but I want the court to understand that it is not the sentence that is challenged. It is the warrants and why they are enforced. The why is a criminal case of escape. And that criminal case, I'm presumed innocent. But if you enforce it, I'm no longer innocent because you are saying that I'm basically guilty of it. Because if the court, if they had said, they opened the case, they are waiting for a finding from the court to say that is the warrant valid or not, that would be a fair determination. But you enforce it, you already made a decision. Thank you.
Thank you. Thank you, Mr. Bester. I think I understand your argument and I've listened to your argument. I
Thank you,
also
sir.
have access to all your papers. Likewise, Mr. Modula. I have read your heads of argument and I've listened to your arguments here as well. I am going to reserve for judgment just to give me some time to consider what was said in court. Judgment will be handed down by uploading it onto case lines and emailing it to the parties. In that regard, Mr. Bester, can be emailing to the
Yes.
attorneys, that's the attorneys that correspondent with us.
Yes, please.
And that will get to your
Yes.
attention.
Yes.
Do you also want me to email it to the
Department, yes, I would appreciate it.
department?
Yes.
Do I have the email addresses of the department?
Yeah, I think, may I
Can
tell
you
you?
be sure that my registrar have the email addresses so I can send it? I don't get a nod from that side. I don't know if you have the authority to nod, but I will send it there in order to make sure that he gets the judgment.
Thank you so much.
Court is adjourned.
Right.